my great pleasure to introduce Professor Kai Hobér, who is going to moderate this session dealing with intra-CIS and old Soviet bilateral investment treaties and their impact on international dispute resolution. Kai Hobér has acted as counsel to numerous corporations and governmental agencies, and he's also widely regarded as one of the most recognized arbitrators dealing with CIS disputes. I think the first time I heard of Kai was when I was still with Freshfields, and we were deciding on whom to appoint as an arbitrator in a particular case. And Freshfields has a secret file on every arbitrator where you could read everything about that person. And certainly Kai was very high on our list because of his reputation. I don't know whether eventually Kai was appointed or not. But in any event, Kai has been following Russia-related and former Soviet Union-related dispute resolution for a while. And since 2016, he has been chairperson of the board of the Arbitration Institute of the Stockholm Chamber of Commerce. And he was the resident managing partner of Mannheimer Swartlings in Moscow between 1997 and 2000. And also, we co-edited a book with Kai on arbitration in the CIS region. I will share a link with you in this in the chat box here. And some of our speakers today did contribute to that book. With that, let me hang the mic, pass the virtual microphone to Kai for him to take over.
Thank you very much, Yuriy. Good morning or good afternoon. Hello, everyone. It's a pleasure to be with you today. And I've been asked to moderate this panel then devoted to investment protection treaties. In fact, as Yuriy said, I have a very long history with the former Soviet Union. I think I have my first arbitration as counsel representing the Soviet Foreign Trade Organization Technoprom Import in 1982, which is probably before many of you were born. And I've been doing Soviet, Russia, Eastern Europe related work ever since in arbitration and in other spheres of the economy. But today we're going to focus on investment protection treaties. And the title is Soviet and intra-CIS Bits, an Unexplored Opportunity. I don't know if there is a question mark or should be a question mark after that or not, but certainly it's to some still an unknown opportunity. And our three speakers today will educate us further on what the possibilities are. I think it's worthwhile remembering before we start this that most of these bits, and including the ECT, the Energy Charter Treaty, were actually signed and ratified by countries of the former Soviet Union at the time, well, just after the disintegration of the Soviet Union, really, at the time when most of these countries were still basically planned economies. So the structure of the economy was quite different from the typical market economy in Western Europe. That notwithstanding, many of these treaties look more or less the same as all the other treaties in terms of provisions and so on and so forth. So from that perspective, really, it's not much news here. But I think there are differences, and I think we will hear more about that today. Differences in terms of how these treaties, how these terms and conditions are applied. And there are some provisions, I think, that are actually taken into account that the countries of CIS were not a typical market economy at the point in time when they were signed and ratified. Some of them may have been renegotiated and amended, but not very many, I think. Of course, these treaties, just like any other treaty, are subject to, governed by, if you will, or has to be interpreted in accordance with the Vienna Convention, irrespective of what the terms and conditions are in a specific treaty. So I think we will hopefully learn a lot more about how these treaties are being applied in practice in disputes between CIS parties and Western parties, so to speak, and the CIS party. So we have three eminent speakers today to educate us on this. The first speaker is Yuriy Pochtovyk, who is at the ECT Legal Secretariat in Brussels, who will talk about the ECT, which is, even though Russia is no longer involved in it, so to speak, an important investment protection treaty, I think, for this part of the world. Our second speaker is Evgeniya Rubinina, who will talk about Soviet bits, an application of them to former Soviet republics. And our last speaker is Ekaterina Grivnova, who will address the definition of investor, which investor obviously is one of the key concepts in all these treaties. Each speaker will have 15 minutes, and I will stop you after 15 minutes. We will take questions after all three presentations. And those of you who have questions, you have to wave your digital hand so I can see it. And you will have basically 1 minute to put your question. And if time permits, we'll have, in addition to question, we'll have sort of an open discussion dialogue. So without further ado, I hand over to Yuriy, please.
So first of all, many thanks to organizers and yourself, Professor Hobér, for having me today. I'm very humbled by this opportunity to present along with my learning colleagues. As announced, my presentation is about CIS investor-state disputes under the intra-CIS treaty. And many from the audience are probably well aware that the intra-CIS process has been launched some 30 years ago in the wake of the end of the Cold War and dissolution of the USSR and Soviet bloc more broadly. And against this backdrop, the 1991 European Energy Charter, a non-binding political declaration, and further adopted intra-CIS treaty were aiming to foster Europe-wide cooperation in energy transit, trade, and investment, and more particularly to accommodate the increasing demand for FDI in the East and increasing demand for energy in the West. But despite such political or historical context, the treaty itself is not confined to facilitate West-East investment flow solely, as confirmed in a couple of so-called intra-EU arbitrations. And that being so, the investor state disputes against the CIS state parties and investor and disputes involving investor claimants having the nationality of one of the CIS member states make up a relatively small fraction of the total number of cases under the ECT. As you can see from the PowerPoint, to date, the Secretariat has tracked 139 investor-state arbitral proceedings instituted under Article 26 of the ECT, and only 28 of those, which is roughly 20%, have been brought against the CIS countries. Here, could you please show the next PowerPoint? Moreover, the nationals of CIS member states appear as claimants or co-claimants only in 6 cases. You can consult the full list of cases involving CIS parties on the 2 following slides of my PowerPoints, which I believe are part of the welcome package for the participants. So needless to say that the ECT does not envisage any special and transitional arrangements for the CIS countries in its investment chapter. Therefore, as far as the ECT as applicable law is concerned, there is no much difference between the CIS-related disputes and any other disputes. Nevertheless, in my belief, the CIS region has generated some intriguing ECT jurisprudence and have produced some, in many ways, remarkable cases. So I would like to take the remainder of my presentation to discuss a couple of those in the context of recent developments. One of the early city cases I find particularly interesting is the Energalliance and Moldova case. The key point there, the key point of contention there was the notion of an investment. One of the claims in the case arose out of a trilateral contractual arrangement involving the claimant as a supplier of electricity, an intermediate agent company incorporated in British Virgin Islands as a buyer, and the Moldovan state-owned enterprise as a payer. The payer's debt owed to the buyer for the electricity supply was then assigned to the claimant. And the tribunal eventually agreed that the assigned debt constituted a claim to money under Article 16 CECT. And by contrast, the tribunal declined jurisdiction with respect to another assignment of debt to Energalliance arising out of a business activity in which the claimant itself did not take any part. At the same time, the dissenting arbitrator Pelliu disagreed with the majority, arguing that under Article 16C, a debt claim must be associated with another pre-existing qualified investment, that there was no any transfer of capital, economic activity of investing or contribution on the part of the claimant, and finally that the electricity had been supplied to the border of Moldova. Therefore, there was no investment within the area of another contracting party. The majority, however, disagreed and decided that the investment was associated with overall investment activity of the claimant. And the majority also refused to read in the ECT any additional requirement, moreover the ones developed in the ICSID jurisprudence. Subsequently, the Paris Court of Appeal annulled the award, agreeing with the dissenting arbitrator. That decision was overturned by the French Court of Cassation, which agreed that the debt claim had to be considered as part of the overall business activity of the investor, and held that appellate court imposed on the investment a requirement that is missing in the text of the treaty. Back at the Paris Court of Appeal in September 2019, the case was referred to the European Court of Justice for a preliminary ruling at the request of Moldova. So now the questions before the ECJ are whether the debt claims under the sales contracts are covered by the ECT, whether the debt acquisition from a non-contracting, from a national or non-ECT contracting party could constitute an investment, and third, whether there was an investment in the area of another contracting party. The decision of the ECJ is expected in the coming months, but meanwhile, just last March, the court's Advocate General issued his non-binding opinion where he opined that a debt claim could not constitute an investment because of the lack of the contribution on the part of the claimant. Secondly, that acquisition of an investment made by a non-ECT national is covered by the treaty, except for the cases of abusive restructuring. And thirdly, that territorial requirement in the present case would have been met since the debtor was located within Moldova, and alternatively, the electricity was supplied for the Moldovan internal market. Switching gears a little bit here, I should mention that the European for the ECJ to answer those questions, they first have to decide that they entertain jurisdiction in the case. For that, they have to conclude that a similar type of situation could arise in intra-EU context. So against this background, the European Commission and several EU member states have intervened in the case, asking the court to decide whether the ACMEA reasoning barring intra-EU BAT arbitration is also applicable to the ECT arbitration. The Advocate General, in his opinion, opines that it indeed does. Moving on to other cases, I believe that the famous first wave UCAS cases together with the second wave Luxton Limited and Russian Federation afford being mentioned as well. Even though they include fairly extensive discussions on definition of investment and investor as well. The key point there is probably the provisional application of the Energy Charter Treaty under Article 45. In a nutshell, the provisional application rules under Article 45 envisage that a signatory of the treaty must apply the CT as a whole pending its ratification, acceptance, or approval according to relevant domestic rules. However, a signatory may choose to opt out from provisional application altogether by making the relevant declaration, or signatory may plead defense under the so-called limitation clause of Article 45.1, which allows to apply the treaty provisionally to the extent it is not inconsistent with constitution, laws, and regulations of a given signatory. Leaving aside the issues of Russian domestic law, I note that the key questions before those two arbitral panels was how exactly the limitation clause of Article 41 operates, whether it is the provision by provision or piecemeal approach, meaning that any particular provision of the ECT does not apply provisionally if it contradicts domestic law, which is essentially the argument of the Russian Federation, or the all or nothing approach, according to which a signatory agrees to apply the ECT provisionally as long as the principle of provisional application is consistent with its domestic law. Both arbitral panels decided that the all or nothing approach should apply. The Hague District Court in UCAS Universal, Veteran Petroleum, and Hewley supported the provision by provision basis and upheld the Russia's challenge of the awards. Nevertheless, the next court, the Hague District Court, annulled the awards, supporting the UCAS shareholders' alternative submission. Under this alternative approach, the limitation clause of Article 45.1 excludes application of the treaty as a whole or treaties provision, much alike provision by provision basis. But in case that such provision or provisions are inconsistent with the signatories' domestic rules on provisional application of international treaties specifically, and not of the provisions that are in themselves inconsistent with given domestic law. The Supreme Court of the Netherlands is yet to decide on the Russia's challenge of awards. Meanwhile, this May, May last year, the Russian Federation requested the Supreme Court to refer certain questions of interpretation to the European Court of Justice, and last month, the Advocate General of the Dutch Supreme Court issued his non-binding opinion on the matter. And among other things, he appears to be taking the view of the appellate court with this alternative approach argued by UCAS shareholders, and concludes that the Russian Federation was bound by the ECT's provisional application. Meanwhile, the shareholders continue their enforcement attempts worldwide. One more interesting case under the ECT involving CIS parties is Stati and Kazakhstan. The facts of the case were the following. The claimants invested in two Kazakh companies holding subsoil use contracts and rights for oil exploration. And the tribunal determined that the respondents' measures constituted a coordinated harassment of the claimants and altogether resulted in violation of the FET. The tribunal awarded the claimants an award of damages in excess of $500 million. The tribunal rejected the Kazakhstan's defense based on the alleged illegality in making and performance of investment, and likewise rejected to read any additional criteria of an investment in the text of the ECT. The award has been upheld at the seat in Sweden and recognized in Belgium, the Netherlands, Luxembourg, Italy, and the US. The enforcement actions have also been brought to the UK. For the time being, Kazakhstan alleges that the award was procured by fraud, namely that the claimants relied on fictitious costs in their case of damages. And most recently, the auditors of the claimants, the KPMG, issued a letter where it asked not to rely on its audit reports used in arbitration because the claimants failed to verify the representations they made to the auditors for the purpose of producing those reports. However, the Swedish Supreme Court.
You are running out of time. In fact, you have run out of time. So if you just say a few more words to wrap up.
Just to wrap up, the Statis family continued their enforcement attempts again worldwide. And just to briefly round up, among few more recent developments is the mentioned today Litop and Ukraine case where Ukraine defeated $6 billion case, which makes it score as the top case in terms of the amount claimed, just right after the three UCAS cases. Also, the very first quote unquote renewable CIS-related case against Ukraine has been instituted, as some documentation surfaced in media. And yeah, so that's about it. Thank you very much for your attention. I'm looking forward towards my colleagues' presentations.
Thank you very much, Yuriy. I'm sure there will be questions to you about the ECT, not least about the reform process or the attempts that are being made to reform it. I'm not quite sure what is going on, but maybe you can enlighten us as we go on or as you get questions. So let's turn then to our second speaker, Evgeniya Rubinina, to address us about Soviet-era BITs application to former Soviet republics. Please, Evgeniya, you have 15 minutes.
Thank you very much, Professor Hobér. And to start my presentation, I just wanted to say thank you to Professor Yuriy and Professor Dawydenko for the invitation to participate in this excellent event. The topic of our today's panel is the path less frequently taken in arbitrations involving CIS states. And one of these potential avenues are the investment treaties concluded by the Soviet Union. In my presentation, I will focus on two relatively recent cases that involved the application of the Canada-USSR bilateral investment treaty to Kazakhstan. And I will try to explore what this means in relation to the application of the USSR's treaties to former Soviet republics. The USSR started concluding bilateral investment treaties at the end of the Perestroika era. It entered into its first BIT in 1989. And before the breakdown of the Soviet Union in 1991, it managed to enter into 11 bilateral investment treaties with Finland, Belgium and Luxembourg, the UK, Germany, France, Netherlands, Canada, Austria, Spain, Switzerland, and South Korea. And these are all quite frequent. We see quite a lot of claimants coming from these states. These are capital exporting states. So there was clearly an interest in securing investments from these countries into the Soviet Union at the time. What is the status of these treaties? Now, after the Soviet Union broke down, Russia announced that it was a state continuator to the USSR, and that therefore it succeeded to the USSR's treaties. It is generally an uncontroversial proposition that the USSR's bilateral investment treaties apply to Russia. And indeed, there have been a number of cases brought under these treaties against Russia, for example, the Beshara case against the Russian Federation and many others. The Baltic states promptly informed the UN Secretary General after the breakdown of the Soviet Union that they do not regard themselves as a party to any of the USSR's treaties. And therefore, it's quite clear that these treaties don't apply to Latvia, Estonia, and Lithuania. Now, what about the other states of the former USSR? Are they bound by the USSR's bilateral investment treaties? Until recently, it was a fairly academic question. Nobody really tried to bring a claim under other former USSR states under the USSR's treaties. That all changed when Bejo Wasani, representing Worldwide Minerals, brought a claim against Kazakhstan under the bilateral investment treaty between Canada and the USSR. Worldwide Minerals was a Canadian mining company, and it brought a claim against Kazakhstan in relation to the termination of an uranium processing business in Kazakhstan. And it argued that the Canada-USSR bilateral investment treaty in fact bound Kazakhstan, because at the time when Worldwide Minerals made its investments into Kazakhstan in the mid-1990s, Kazakhstan maintained in its various public statements and presentations to foreign investors that this treaty was in force in relation to Kazakhstan. A very eminent tribunal heard this claim. It was composed of Professor Rusty Park, Sir Franklin Berman, and John Crook. So you can hardly accuse this trio of not being familiar with principles of public international law on state succession. And unfortunately, the award in the Worldwide Minerals case is not publicly available. So we have to make do with reports in various newsletters, as well as with the press statements made by Worldwide Minerals and by the Kazakhstan government. But we understand from these statements that the tribunal heard evidence from representatives of the Canadian government at the hearing, and they confirmed that at the time it was their understanding that the BIT indeed applied to Kazakhstan. And one other piece of evidence that was looked at by the tribunal is the 1997 Free Trade Agreement between Kazakhstan and Canada, and the preamble of that free trade agreement referred to the agreement for the promotion and reciprocal protection of investments between Canada and the USSR. So that was sort of circumstantial evidence pointing towards both states thinking at the time that this treaty was in force between them. Now, Kazakhstan was quite unhappy with the decision of Worldwide Minerals that found that the Canada-USSR BIT applied to Kazakhstan, and it tried to set aside the award. This was an UNSCHL case with the seat in England, so it tried to set aside the award before English courts. And as some of you may know, the deadline for bringing a set-aside application before English courts in relation to an arbitral award is 28 days. And Kazakhstan was slightly late in bringing its set-aside application and brought it only 959 days later. And for that reason, the judge, Sir Michael Burton, declined to hear that set-aside application. But it was not an entirely straightforward decision, and it's actually a very interesting one because it's one of the few documents in the public domain available about this case and about another case to which I'll get in a second. Kazakhstan tried to justify its very late set-aside application by the fact that in another case brought against Kazakhstan under the Canada-USSR bilateral investment treaty called Cold Pool, some new evidence surfaced which suggested that Canada didn't actually think that the BIT was binding in relation to Kazakhstan. But the English judge declared that this was not a game changer, as he called it, and therefore that it didn't justify waiving the provision about the deadline for bringing a set-aside application in relation to an arbitral award. Now on to the gold pool case. Several years later, in July 2020, another tribunal hearing another case by a Canadian investor against Kazakhstan reached a diametrically opposite conclusion. This was also a very eminent tribunal. It was composed of Albert-Jan Vandenberg, David Williams, and Gabriel Bottini. This was actually a much larger case in quantum. It was for $900 million US, and it related to the termination of a gold mining concession by Kazakhstan. And again, the award is unfortunately not public. Now, in this case, Kazakhstan was represented by a different team of lawyers. It was represented by Reed Smith in Worldwide Minerals, and it was represented by Curtis in the gold pool case. And in that case, Kazakhstan managed to offer some additional evidence, it seems, to the tribunal as to whether both states thought that that treaty was in force in relation to Kazakhstan. And we know about this from a press release that Kazakhstan issued when it was victorious in the gold pool arbitration. And we also know from the set-aside application before English courts in the Worldwide Minerals case what one of these documents was. Apparently, in the document production exercise in gold pool, the investor produced a letter that it wrote to a Canadian minister, and no response from that Canadian minister was produced. And then through various means, first through a Freedom of Information Act, and then through document production, the arbitration, Kazakhstan managed to obtain a copy of the response from the Canadian minister to the gold pool investor. And it seems that that response suggested that the treaty between Kazakhstan, the treaty between the USSR and Canada did not apply to Kazakhstan. So while the English judge did not consider that letter to be a game changer, it seems that perhaps taken together with some other evidence that was presented in Worldwide Minerals, in gold pool, the gold pool tribunal did consider that this additional evidence was quite important. Now, which of the approaches taken is right? Is it the Worldwide Minerals Tribunal or is it the Gold Pool Tribunal? And to try to explore that, we will need to look at the general public international law framework on state succession in relation to international treaties. And there is in fact a Vienna Convention for that, but not the Vienna Convention on the Law of Treaties. There's a separate convention, the Vienna Convention on State Succession to International Treaties, which was concluded in 1978, some time ago. And unfortunately, it doesn't have a whole lot of parties to it. Only 23 states have ratified it, and neither Canada nor Kazakhstan are parties to it. And it is quite arguable that even at the time when that convention was first signed, it didn't fully reflect the state of customary international law in relation to state succession. And even more so, since 1978, there has been a whole lot of state practice which deviates from the approach that was taken in the Vienna Convention on State Succession. Now, the two approaches to state succession to international treaties enshrined in the Vienna Convention on State Succession are first a continuity approach, which under that convention is to be taken in the case of the dissolution of unions between the states. So one example of that is the dissolution of Czechoslovakia in the early 90s. And in that case, both Czechia and Slovakia have taken the approach that they are bound by Czechoslovakia's treaties, including its bilateral investment treaties. And in fact, if you look at cases brought under BITs under Slovakia, they usually discuss in a fairly matter-of-fact manner that yes, Slovakia accepts that it is bound by Czechoslovakia's BITs. And then another approach that can be taken is the clean slate approach. And under the Vienna Convention on State Succession, the clean slate approach is to be taken in relation to post-colonial states. So when a state becomes independent after being part of a colonial union. Now, which of these approaches should apply to the dissolution of the Soviet Union? It is not entirely clear, and it appears that states of the former Soviet Union have generally followed the clean slate approach, but the practice is not entirely consistent Some former Soviet republics have accepted that they're bound by certain multilateral treaties, for example, by the International Labor Union's conventions, but they have acceded de novo to some other treaties. There's also some interesting practice in relation to the dissolution of some other unions which are not the Soviet Union. A very interesting case was rendered under a BIT between Russia and Yugoslavia, which is the case of Deribaska against Montenegro. Unfortunately, once again, this award is not public, but there are numerous reports in the public domain of what was held in that award. The tribunal found that the Russia-Yugoslavia BIT does not apply to Montenegro, and therefore it appears that the tribunal preferred a clean slate approach in the absence of any evidence that Montenegro actually considered itself bound by that treaty. Now, which approach should be preferable in relation to BITs of the USSR? Are we going to see more claims under these BITs and perhaps not just against Kazakhstan by Canadian investors, but maybe against some other former Soviet Union republics? I don't think so. I think that the analysis in the Worldwide Minerals Tribunal was fairly fact-specific. It is almost akin to estoppel. It was very much grounded in the specific facts of that case. And even then, we know that in similar circumstances, the Gold Pool Tribunal reached a very different conclusion. And it also seems that other Soviet Union republics, former Soviet Union republics, and not just the Baltic states, followed a different practice with respect to Soviet BITs. And in particular, I note that some of these former Soviet republics actually went on to conclude new BITs with some of these 11 states with which the USSR had entered into BITs. So that would suggest that they didn't actually consider that these Soviet BITs were binding on them. So for example, in 1994, Belarus concluded a BIT with the UK, even though there was a UK USSR BIT. So the fact that the parties considered that they needed a new BIT suggests that they thought that the USSR BIT was not binding on Belarus. And in general, in light of the very sort of specific quid pro quo nature of bilateral treaties, and even more so bilateral investment treaties, it seems that the rules on automatic succession are not necessarily appropriate or optimal for these sorts of treaties. And a distinction can be drawn with multilateral conventions, and particularly with human rights treaties, where there's a great public interest in these treaties being in force in relation to successor states. And generally, it would also be quite undesirable to have a different approach in relation to Kazakhstan and as compared to other states of the former USSR. It would be quite strange. So to conclude, my view is that the Worldwide Minerals case is likely to be an outlier, and that the gold pool approach is likely to be followed by future tribunals. I'm not aware of any other cases currently brought under former USSR treaties, but I think this is going to be the approach taken in the future. Thank you for your attention.
Thank you very much. Has the gold pool award been challenged?
I don't believe so. I haven't seen anything in the public domain. And I know that the investor has made some noises after the award was rendered, that it was very unhappy with it, but I'm not aware of it being challenged before English courts. I think the seat was also London for that arbitration. Okay. So it seems that we're not going to see a review, which would have been interesting because English courts adopted de novo approach to the review of jurisdictional findings of investment tribunals. They like to express their own view on what was appropriate. Yes,
on most things, it seems to me. Yeah. Thank you very much, Evgeniya. Let's move on then to Ekaterina to enlighten us about the definition of investor.
Okay, thank you so much. So as announced in the beginning, I will address today some unexplored opportunities that might lie within the definition of investor in CIS and Soviet BITs. So as you all know, international investment treaties would only apply to investors if these investors qualify for coverage under the relevant provisions. And these provisions might be somewhat specific and more specific in some BATs than in others. And I would submit that this is the case of some BATs in the post-Soviet region. What we'll do is that I would start with some general criteria for being an investor under CIS treaties. So I was on the general criteria for being an investor under Soviet and CIS BATs. When I say general criteria, I mean the criteria that are not very specific to the CIS region and might be found in BATs all over the world. And generally, the BAT would distinguish between the natural persons and the legal entities. So we would follow this distinction, and we will see all the criteria one by one. And I'm taking here an example of Russia. This is just to give you an idea of numbers, but normally all these criteria are equally present in BATs of all other CIS state members with different proportions. And I've seen a message from Sergei Grishko in the chat box saying that we need to consider different CIS state members differently and separately. And I think one of the approaches that we can undertake is to see how different the combination of these criteria are like for the definitions of investor and investment. In what concerns Russia, Russian BATs generally base nationality on the law of the state of claimed nationality. That means that to qualify as an investor, a natural person must be a citizen in accordance with the laws of the state of origin, with only one exception, which is which is Germany, because German USSR BAT provides for the permanent residence in the state of origin and not for the citizenship in the state of origin. And often it is in the only criteria that we see for the natural persons, even though some BATs would provide for some of the additional link beyond nationality and residence. For example, as you can see on the slide, under some BATs, to qualify as an investor, a natural person must not possess the citizenship of the opposing party or must make an investment in accordance with the legislation of the host state. And these last criteria must be distinguished with the more classical legality requirement that we normally see included in the investment definition. You also see from this slide at the very bottom that 36 Russian BATs oblige the investor to be competent to invest in the territory of the opposing party. But this is the CIS specific requirement that we will see just in a couple of minutes. As for the legal entities, Russian BATs essentially rely on the place of constitution or incorporation, still in accordance with the laws of the state of origin. This criteria is often coupled with the seat or the real economic activity criteria. And as for the real economic activities criteria, we see this criteria much more often in other BATs, in the BATs of other CIS member states, for example, in Belarus or Azerbaijan. Also in Russian BATs, we would see that the investor must make the investment in accordance with the host state laws, and same as for the natural persons, 36 Russian BATs would oblige an investor legal entity to have a competence to invest. So let's focus on these last criteria, which is the CIS specific criteria. First, so in fact, like on this slide, you can see an example of such requirement, of a definition of investor containing such requirement. And as you can see from this slide, an investor under this provision is required to be deemed competent, sometimes with the authorized or entitled under its own laws to make investments in the territory of the opposing country. So these competence requirements appeared first in the Soviet treaty drafting practice due to Soviet restrictions on foreign trade. And as Mr. Hobér outlined just in the beginning, we were in the state of planned economy. So this planned economy justified the inclusion of this criteria, because initially in Soviet Union, there were only like very few organizations that were permitted to invest abroad, and these organizations were handled by the Ministry of Foreign Trade. Then at the end of 80s, all companies received the right to invest abroad, but they were supposed to register first within the competent authorities. And finally, in July 1991, all companies and all legal entities and all natural persons received this unconditional right to invest abroad. So the competence requirements was removed from the internal Russian law. But despite this fact, Russia kept including this criteria, the corresponding criteria in its BATs till 2000. So Evgeniya gave us 11 Soviet BATs that were concluded at the Soviet period. So these BATs most likely include the competence requirement, but not only these BATs, because the last BAT containing the competence to invest requirement was concluded in April 2000 with Slovenia. Why it can be important not only for Russia, but also for each CIS member state to consider this requirement, because there is not a single state in the CIS space that would not have at least 3 BATs in force containing these requirements. So it might be of interest for all these countries that concluded BATs containing the competence requirement to consider its interpretation. And I think that here we come to some unexplored opportunities, or better to say to some unexplored arguments, because the competence to invest criteria had almost never been discussed in case law. So I looked through all treaty-based cases involving CIS member states or investors from CIS member states, and I have only managed to find 2 cases that briefly touch upon this requirement. It was Bogdanov versus Moldova and Kvasar de Valores versus Russia. But in that cases, the tribunal did not really rely on and did not really take further on the interpretation of this criteria. But the things are very different with recent Pugachev case, where it is from June 2020. And in Pugachev case, the tribunal heavily relied on the interpretation of the competence to invest criteria to dismiss all the claims of Sergei Pugachev against Russia. For the brief context, Mr. Pugachev is a Russian businessman and a politician. He was also naturalized French in 2009. So he's a dual national of France and of Russia. And he claimed that Russia allegedly expropriated his investment. The tribunal first decided that the BAT, the applicable USSR France BAT, did not exclude the protection of dual nationals. So Sergei Pugachev could potentially invoke this BAT, but then the tribunal split. That means that we will have the majority decision and a dissenting opinion. The tribunal split over one issue, is whether Sergei Pugachev was supposed or not to be French at the moment of the investment. And the tribunal, the majority, used the relevant definition of investor, and you see it on the slide. Under these definition of investor, a natural person was supposed to be permitted to make investment on the territory of another state. So Sergei Pugachev was supposed, under this provision, to be permitted by France to make investment in Russia. And under the majority reading, that meant that to invest in Russia, you needed to have been permitted to invest in Russia under your own country's laws. But to be permitted by your own country to invest, you needed to be its citizen first. And Sergei Pugachev was not a citizen of France at the moment of the investment, so the tribunal dismissed all the claims. There was one arbitrator dissenting. Professor Clay outlined, among other arguments, that the provision in itself was worded in the present tense, so it was written is permitted, not was permitted, then normally this competence to invest requirement was only included from the Soviet perspective, so it must be overridden for French investors, such as Pugachev, and the jurisdiction must have been assessed on two crucial dates, which he considers to be classical in investor-state arbitration: the date of the injury, so of the alleged treaty breach, and the date of the introduction of the arbitral proceedings. And for Clay, donc for Professor Clay, Pugachev qualified as an investor, and his claim should not have been dismissed. So what unexplored implication can we draw from Pugachev case? So first, Pugachev case provided us with a powerful argument for the arbitration that involve dual nationals. If the applicable BAT contains a competence to invest requirement, right now we can argue that the dual national was supposed to hold the relevant nationality at the time of the investment. And also the opposite argument can be true if the BAT does not contain such requirement. And secondly, Pugachev case showed us a situation that we might potentially want to avoid or anticipate during the treaty drafting process. And on this slide, you see an example of such an anticipation. This is a EU-Vietnam foreign trade agreement that was concluded in 2015 when Pugachev sued Russia. And the EU-Vietnam FTA provides that the neutral person not possessing the nationality of a party to this chapter on the date the investment were made may not pursue a claim against this party. And we can even go a little bit further with this, and we can even say a natural person not possessing that nationality, the nationality of a party to this chapter on the date the investment were made, may not pursue a claim at all. So in any case, I think the Pugachev matter showed us that this competence to invest requirement is not to be ignored. It is not to be neglected, because this is an element negotiated and accepted by the states in more than 80 BATs in force in the CIS region. So we can consider this as a delay action bomb that can explode in any further case. So thank you for the attention. Would be happy to pick all your questions.
Very much, Ekaterina. Well, I mean, this illustrates perhaps, I mean, since I was quite heavily involved in Soviet foreign trade, I know that the competence to invest was in those days an important aspect of foreign trade. But of course, as you pointed out, even before 1991, when it was formally abolished, in practice, it didn't really apply in the late 80s either. But you know, once you have put it into a treaty, you have to interpret that language based on the Vienna Convention. And in this respect, I think one can say that the Vienna Convention is a bit rigid, because you typically do not take into account changes in real life, so to speak, after the treaty has been signed and ratified. So it's very often a tricky situation for the arbitrators, I think, to deal with this particular and similar situations. So thank you to all three speakers. We now open up for questions.
And my question is actually for Ekaterina. I was wondering whether you followed the most recent practices dealing with defining investors in investment treaties. How radically different are they from what we have in the old treaties, including those attempts to reform the old generation treaties initiated by UNCTAD and different countries? Thank you.
Thank you, Yuriy, for the question. I think that the global tendency, not only in the CIS region, but all over the world, is to be the most concise possible with the definition of the investor. So normally we would say that an investor is a person who is constituted, or who has a citizenship in accordance with laws of its state of origin. And I think this is the global tendency, at least for Russia, because I tracked this one to do the presentation. But I think that globally we see the same trend in the BATs of other CIS members as well.
Yeah, I think, if I may add, as many of you know, the definition of investor in most BITs, not only CIS BITs, but most BITs, are usually quite broad. And so they have to be read together with any benefits of denial clauses that you have in order to, because otherwise you would, many BITs do include what we call mailbox companies, just based on the definition of investor. And the remedy to that, so to speak, is to have a denial of benefits clause. But you have to think about how you draft that denial of benefits clause then to make sure it hits the target, which is not the case, I think, with Article 17 of the ECT, for example, which has, as far as most tribunals are concerned, they have not applied it at all. Okay, Evgeniya, do you have a question?
Yes, in fact, I have a comment and a question on Yuriy's presentation. My comment is that in line with our general theme of our panel, sort of past less taken or more taken, it seems that in cases involving CIS states, a lot of the claimants under the ECT Cypriot claimants, and because this is a very common holding, a very common jurisdiction to incorporate holding entities in relation to assets held in CIS states. And actually not many CIS states have BITs concluded with Cyprus. Ukraine doesn't have one. Kazakhstan, I believe, doesn't have one. Russia doesn't have one. So the provisional application under the ECT is still sort of occasionally used by Cypriot entities. So that seems to be one reason why the ECT is a popular instrument for bringing claims against CIS states. And the question was actually quite different. I was intrigued by the 2080 split slides in Yuriy's presentation showing claims against CIS states and against non-CIS states. I believe that a large chunk of these non-CIS states who are respondents in ECT cases are states against which claims were brought in relation to the curtailing of renewable energy programs, and in particular Spain accounts for a large chunk of that. And we know that the first claim has been brought against Ukraine in relation to its feed-in tariff program for renewable energy producers. Do you think that in light of that, we will see an increase of claims against CIS states under the Energy Charter Treaty?
Yuriy, please.
Many thanks for the question. So indeed, over the years of 2008 to 2014, a number of EU member states introduced some somewhat generous incentives for renewable power generation. As a result, between 2013 and 2016, we could see a tremendous increase of renewable regulatory disputes, and namely in Spain, indeed. So overall, those probably now account for some 60% of disputes under the Energy Treaty. As to Ukraine, it remains to be seen. The first case of this Dutch subsidiary of Lithuanian Modus Group has been brought, I guess, in March. They've instituted arbitration under the SCC rules. There is anecdotal evidence that there are some other investors who have served triggering letters to the Ukrainian government. But as media reports, a bulk of investors have negotiated some deal with the government through if I'm not mistaken, this Vienna-based energy organization. So yeah, we just have to see what's gonna come. And I must note that under the treaty, obviously there's no any rule that investors or host states should notify the Secretariat of their disputes. Therefore, some awards and decisions and the very existence of some disputes remain confidential.
Well, I think the Ukrainian government should have learned a lesson by looking at what the Spanish government has done and not done. I mean, these cases are obviously generated, I mean, basically on what the regulatory framework says or doesn't say. So, and you have to be, as a host state, you have to be careful, obviously, when you change the rules of the game. But Yuriy, tell us, please, a little bit about the modernization attempts of the ECT and how that relates, if at all, specifically to CIS states.
Sure. And I'm also seeing one more question on modernization in the chat box, so I could probably address both.
Okay, sure. Go ahead.
As to modernization, obviously under the current mandate, all public communications are issued by the Modernization Group, a subsidiary body of Energy Charter Conference, which is in charge of negotiating the modernized Energy Charter Treaty. Therefore, I'm to some extent limited in what I can publicly say, but you could consult the so-called public communications by the Modernization Group on the Secretariat's website or the website of the Energy Charter Treaty, energychartertreaty.org. We aim to publish public communications straight after each negotiation round. So we concluded the fourth round now, and we are reconvening for the fifth round of negotiations just in a week time on the 1st of June. As to the current progress, you could see from the public communication from the previous round that for the first time, the text-based discussions on the definition of economic activity in the energy charter, in the energy sector, Article 1.5 of the treaty, took place. Arguably, that's a hot topic, if you will, for the current negotiation process, because for that one you can basically shape the type of investment and type of fuels and energies that will be protected in the future. As to CIS countries vis-a-vis modernization, well, on the list of the 25 topics for modernization, you could see, for example, transit-related topics. So I must remind that ECT is not a solely investment protection treaty. It covers trade-related measures, transit, and investment. For some of the Central Asian countries, transit remains to be topical, unlike maybe for EU, which now has their own internal market. So maybe this one is a bit related to the CIS region. Otherwise, there is not that much of specificity in modernization with regard to CIS countries.
Are there any discussions concerning Article 7, precisely on transit, in these modernization discussions?
The definition of transit is precisely on the list of topics for.
Okay. Because Article 7, I think, was at least supposedly one of the reasons why Putin didn't like ECT, because it couldn't solve the problems between Russia and the Ukraine, in his view. So, I mean, it's a very ambitious article of the ECT, but it doesn't really, I think one has to say, provide a solution, a realistic solution to transit problems.
Well, in principle, Article 7 provides that the contracting parties should not stop any transit despite any kind of crisis or issues they're having there. But some years ago, the Secretariat has produced a so-called early warning mechanism, sort of soft tool for helping to ease transit conflicts. Unfortunately, it didn't help in Ukraine-Russia crisis back in time. And speaking of Russia, just final remark, because I see this question in the chat box. I must remember that Russia was a signatory. I mean, still is a signatory, and it had been applying the Enyo Treaty on provisional basis from the date of signature to 2019. To which extent it's a subject of ongoing litigation in some disputes. But in 2019, the government of the Russian Federation served a declaration to the depositor of the Enyo Treaty, Portugal, where they indicated their intention not to become a contracting party to the Enyo Treaty. Therefore, Russian Federation is not the contracting party and does not take part in negotiations.
Okay, thank you. Yuriy, did you have another question?
Yeah, I was wondering whether any of the panelists remember the most recent developments related to UCOS in the Dutch courts, or because I just haven't followed recently. Anything interesting there?
My understanding that there was a hearing earlier this year before the Dutch Supreme Court, I think it was in January, and that a decision is pending. But Yuriy probably knows more about it.
Well, didn't you say, Yuriy, that the Supreme Court is now going to decide whether or not to transfer it to European Court?
Exactly a year ago, the Russian Federation requested the Supreme Court to refer certain issues, 9 issues, if I'm not mistaken, dealing with the interpretation of the Enyo Treaty to the European Court of Justice. And the most recent development, as I mentioned in my presentation, was the decision, the opinion of the Advocates General or Courts Advisor of the Supreme Court of the Netherlands of 3rd March 2021, where he commented on many of the issues, including the issue of the referral to the European Court of Justice. In his opinion, this referral is unwarranted. So it again remains to be seen what they're going to decide there.
Yeah, so there's no decision yet by the Supreme Court on that. So the issue is still pending. So it may well end up in Luxembourg, European Court. More questions? Or may I just add, perhaps, in respect to what Yuriy mentioned about the ECT, it has become, as many of you know, a very important investment protection treaty in the energy sector. But as Yuriy mentioned, the ambition when the treaty was drafted was to be much more than simply, so to speak, an investment protection treaty. It had provisions on trade, on transit, environment, and so on and so forth. But for a number of reasons, I think in real life, it has become an important document, primarily in investment protection sphere. As far as trade is concerned, when the ECT was drafted, the WTO didn't even exist, and many of the negotiating member states became members of the WTO rather late. But now most of them are. So all trade-related issues are really, in energy, are really covered by the WTO agreements. Any further questions?
Dear colleagues, my question is the following. In Russia, there is an opinion that Energy Charter Treaty was well, formulated in such a way that it is more favorable to those parties which, so to say, buy energy than those parties, states parties, than those state parties which produce energy. What do you think about this opinion, whether this is a balanced treaty or not, or whether there are any alternatives to this treaty?
Yuriy, do you want to address that?
Well, it's I would say that's quite a difficult question to answer. I personally have no opinion on that. I don't see any bias towards supply or demand countries. But, well, in principle, there has always been this perception of investment regime being biased in favor of capital exporting countries. So you could argue this with respect to any kind of investment treaty.
And do you see, Yuriy, any backlash against the ECT, as we see backlash against, let's say, ISDS within the framework of unilateral discussions? Some states are very unhappy. They want to reform the system completely. Do you see that the ECT is sort of immune from that, or you also have a share of these criticisms, sort of that investors have too much powers and states' rights to regulate are limited and so on?
Well, surely the ECT has been a subject of criticism from civil society for a while. And when it comes to ECT, here is the issue not only of ISDS itself, but also the issue of the economic sector it covers, because energy is quite politically sensitive field, and it also has much to do with the climate crisis. And so, yeah, we've observed some criticism of the treaty, but this current negotiation exercise is exactly the momentum to address many issues, not only of ISDS, but also of climate ambitions of certain contracting parties.
If I may add a few words on that topic, I think many of you know that the European Commission is trying to extend the ACMEA reasoning, whatever that is, to the ECT. And you also know that many tribunals, in fact, I think more than 35 now, have been confronted with the Commission's ACMEA argument concerning intra-EU bids, and not one single tribunal has agreed with the EU on that topic. But I mean, the ECT is under fire, just like bids are in general from certain quarters. But there are different critical voices. I mean, the one coming from the Commission is based on the idea that it should all be handled within the EU system. But of course, the ECT also suffers, so to speak, from the general criticism, as you mentioned, Yuriy, against the investor-state dispute settlement mechanism. And to answer your question, Dmitry, about the Russian view of the ECT as being unfairly slated in favor of investors, I think there are two comments to be made. First of all, that's the original purpose of any investment protection treaty, to protect investments. So that's why they are by nature one-sided. And that's why under most treaties, host states do not have, cannot raise counterclaims, for example. You can think that is bad, fine, you have to renegotiate the treaty. But if you look at all treaties today, that's basically, the idea is to be a one-sided treaty protecting foreign investment. The philosophy being that by protecting foreign investment, you entice more foreign direct investment into your country. So that's the whole philosophy behind an investment protection treaty. If you want another kind of treaty, yeah, I mean, you can obviously negotiate that. I mean, if you want to have a broader free trade agreement with an investment protection element, fine. So that kind of criticism, I mean, it's banging in open doors, really, because the whole point is to protect investments. As far as the Russian view is concerned, I think it's very much connected to the Yukos case, quite frankly. I mean, when the Yukos case started, it was the time when Medvedev was the president, and they came up and they were talking about we're not, we're going to withdraw from this, blah 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 blah. So, and he came up, Medvedev, or the presidency then came up with an alternative, international energy security treaty or something like that, which was I have to say, very watered down version of a investment protection treaty. So I think, I mean, I might sound a bit cynical now, but I've been around for a couple of decades. So, I mean, you get a bit cynical sometimes when you hear criticism coming from certain quarters. And I think in the case of Russia and ECT, I think the Yukos case explains quite a lot. I'm not saying the Yukos case necessarily was decided in the right way. I mean, that's a different discussion. But, if you sign a treaty as a state, obviously there's a risk that someday you will end up as a respondent. That's part of the game.
Thank you. Thank you, Kai. So are there any other questions or comments from the floor? If not, then we can finish a bit earlier because people may want to have lunch if they're
sure
in the West. Yeah.
If there are no questions, let me then, in my capacity as moderator, thank the three speakers for very interesting contributions. I mean, all very relevant, and I mean, this discussion will continue with or without a reform of the ISDS system. We will always have some form of investment treaty or investment arbitration in the future. So thank you very much, and thank you, Yuriy, for inviting us all.
Thank you.
Thank you. Do you want to say something to finish off?
Yes, thank you very much, Kai, for skillfully moderating this panel and also for sharing your experience. And I know that last year you published a commentary on the Energy Charter Treaty, which you very modestly did not mention in your comments, but it's an excellent book, a very thick one. Oh, Yuriy is trying to check his shelf, right? Okay, this is it. So you see, even the Energy Charter Treaty is a very serious source.
I'm already working on the second edition. There are many new cases that come out. So in a couple of years, there will be a second edition, perhaps.
Excellent. We'll very much look forward to it. Thank you very much, Ekaterina, Evgeniya, Yuriy, and Kai. And I hope to see you tomorrow morning at 9. We will not sort of disconnect all the panelists and participants now. But if you need to go, feel free to go. If there are any other further questions or you want to chat, then please feel free to stay. But the formal program is now over for today. Thank you very much.
Thank you. Thanks. Bye-bye.
Thank you, Yuriy.
Professor Hobér, if you have 1 minute, I have a question to you. When I was in Hamburg at Max Planck Institute of Private International Law, I came across your book about, as far as I remember, enforcement and recognition of arbitral awards in Russia or CIS, probably Russia. It was dated, I think, early 90s, no, maybe mid 90s. So I guess you are in this field for three decades, yes?
Well, several hundred years, not quite.
So about 3 decades.
Yeah.
How did it happen? Maybe it's a very large question that you became so much interested in this region.
Well, I mean, I'm since I've retired now, both as a professor and as a practicing attorney, I'm now thinking about my memoirs. So sometime, I mean, the working title is My Life as a Russian.
Yeah.
Well, it started out really, it started out in the Swedish Army, where I went to something called the Army Language School. And this is the early 70s, the Cold War, where they taught you nothing Russian, nothing but Russian. So that's how it started. And then when I started out in private practice in 1982, I was one of the few non-Russian lawyers who knew Russian well enough to, use it professionally. So my first day in my firm was in 1982 when I became involved in this case, which is now in the public domain between Pilkington, Britain, and Technoprom Import. So that's how it started, and then my first major publication in this field was the book which came out in 1989 or 1990 called Joint Ventures in the Soviet Union. A very thick book, which became the definitive book in English on joint ventures in the Soviet Union, not necessarily because of its qualities, but because the Soviet Union disappeared before anyone else had time to write anything. So from when the joint venture decree came out in 1987, and from 1987 till the end of the Soviet Union, so to speak, I worked very much with joint venture matters, representing mostly Western investors, and also in those days helping Gorbachev, so to speak, to draft market economy-oriented legislation, which never came to fruition. And then, so that was really my first, really serious go at Soviet law in those days. And then I worked in the early 90s, I worked with Goskomi Imущество and Chubais. So I was involved in drafting privatization legislation. Not that I take any responsibility for it, but I was there. So that, and then it has, just rolled on. So I spent more time in Russia than in any other country except Sweden.
And I guess apart from that, you spent much time on arbitrations as an arbitrator with the Russia-related cases.
Yeah.
And also with our former head of our department at GIMO, Professor Lebedev, I guess, your colleague. Yeah. So
no. Sergei Lebedev was, in fact, the first case, and I'm getting into my old stories, but the first arbitration case involving a Soviet foreign trade organization, which actually went through to an award. The Technoprom Import case settled, but the first case that went to an award was a case between Suda Import, where I represented Suda Import as counsel, and we appointed Professor Lebedev as our arbitrator, so to speak. We were respondents. This was against a Turkish, or claimed was a Turkish businessman. So, and since then I've had many dealings with Professor Lebedev, and he was a great fan and friend of Sweden. So we spent many years together in Sweden, so to speak, and also UNCITRAL arbitration working group.
Yeah, thank you very much. And all this experience, in my opinion, is very relevant today, because our today's life is much determined by what happened also in Soviet Union and in arbitration involving even these awards and the books and your future memoirs, I think are very relevant for today's life. Thank you very much.
You're welcome.
Yeah, so hope to see you tomorrow and at later.
Well, I'm afraid I will not be there tomorrow. I will be dealing with something. I can tell you this because it's not only complete secret, but I'm actually finishing a report tomorrow that I've done for the Swedish Foreign Office concerning a Russian submarine, which sank outside the Swedish coast in 1916 during the First World War. And the Russian authorities have now asked permission to come and pick it up and bring it back to Kronstadt or St. Petersburg. And the Swedish government will have to decide, based on my report, whether or not to do it. I will not tell you what my conclusion is, but at some point, sometime, you will read about it. But that's why I can't be with you tomorrow.
Yeah, okay. So at later events. Thank you very much.
Thank you.